Hey everybody, Jimmy Smith coming at you with a little something different today. Cain Velasquez pleading no contest in his obviously against a litany of charges. We're going to get into a second. I thought I'd bring in a legal expert, Patrick Donahue, a criminal defense attorney here in South Florida, also a teammate of mine. He's a Carlson Gracie Brown belt, very good friend. Thanks a lot for joining us. So, Pat, one thing I want to ask you is earlier on when you and I discussed this while we're training, whatever, the free Cain signs, all this stuff. I had a colleague of mine, Jen Brown, on my SiriusXM show, did a great podcast series about it. It was all about bond. And you said to me, he may or may not get bond, but I don't see a compelling argument that he didn't do it. I don't see a compelling argument that's really going to work in a criminal trial. It looks like Cain and his team saw the writing on the wall. What can you say about that?
Yeah, I definitely agree. It's actually very interesting what's been going on behind the scenes. California doesn't have open public records like Florida does under the Sunshine Law, but I have been able to do a little investigating and seeing a couple of things that led to this no contest plea and why we're not seeing a trial and why we're going straight to the sentencing phase. It's actually very interesting. Just to back up a little bit, so this case is almost 2 years old now. And the big issue at the bat was why is Cain in jail when and I have to use these words because unfortunately, or the case isn't closed yet, but the why is the alleged child molester allowed to be out on bond, but Cain's not? And it felt hypocritical. It didn't feel right. It didn't feel like the justice system was doing what was supposed to be done. And his lawyer, who is a very famous criminal defense attorney, he's worked on a number of high profile cases. He took the case to the media. He had press conferences. Of course, we have to have candor and we have to be respectful, but he did drag the court and the state attorney through the mud and basically had press conferences saying, why is he not out on bond? And now his attorney has changed, which is interesting because once he got out on bond, I think the tactics have shifted. I'd like to go a little bit into that if that's all
Please.
all right with you. Yeah.
Yeah, man, you're the expert.
So I wouldn't say an expert, definitely a brown belt though.
In jiu-jitsu, I
so
got you. Legal field, you're the expert.
Yeah, well, I've done everything from traffic trials to life felonies. So I definitely have some experience here. But what's interesting about this case is I was wondering what they're going to do with a CTE, temporary insanity defense. We haven't really seen a lot of athletes use something like that. The only one that I can really think of is I think War Machine back when he had his terrible case with Chrissy Mack. He I think he touched on that a little bit. And what we're looking for really is not understanding the difference between right and wrong, right? Some type of insanity plea. In law school, they teach you, you catch your wife cheating on you, and you're so inflamed that right that second you catch your wife cheating on you, and you shoot them both. Right, that wasn't a planned, premeditated murder. That's I lost my mind. I couldn't decide what was right and wrong. And I was very interested, and I think the early court filings started to touch on with his first attorney of some type of insanity CTE defense. And as you know, with CTE, Jimmy, you know more than this because you do a lot of fighting commentary. When is CTE diagnosed mostly?
Well, you can only find it after death, but the signs are usually a
Exactly.
bit, yeah, right around now, a few years after retirement is when you start seeing the signs, but it can't be technically diagnosed except on a cadaver.
Exactly. So now you're trying to do a legal defense of temporary insanity based on CTE, and well, there's really no diagnosis here. It's not like we could, get this checked out and it's a positive or negative. So they'd have to hire an expert. And just because you have an expert doesn't mean the court's going to accept the expert. They might say, oh, yeah, sure, that guy's saying he's got CTE and it's temporary insanity, but we don't accept that because, like you said, diagnosis only after death. And then there's some bad evidence that came out. So what I saw was two really terrible pieces of evidence for Cain is somebody caught this on video. They didn't catch the shooting part, but you can see uh, Cain allegedly following the mother and father with the alleged child molester in the back seat. And there's damage to both cars. Like it looks like he pushed his vehicle into the other vehicle. Like it's not good because now we have the jury can see that. And then I just saw from the press release from the state attorney's office, they got Cain's cell phone and he Googled at some point, this is not verbatim, but something like family of child molester, legal culpability for going after the child molester, and cases where somebody's done something like this. And now, guess what? We don't have any temporary insanity. Now we got premeditated. He thought about this. He went through it. He looked up cases. You got to be very careful what you do on your cell phone because these state attorneys, they know that people Google everything. They got Casey Anthony. I mean, she walked, but they got her with the same thing. They pulled her Google records. So nothing's safe, and it's not like it used to be.
But when you look at this, the other side of it that we were thinking might work is once again an all-in kind of defense, jury nullification, which first off, explain to my audience what jury nullification is and whether or not that would have been kind of a way that Cain's defense could have gone had he chosen to go to trial. Ultimately decided not to, but was it this idea of, all right, that's putting a lot of chips on 42 black, hoping it works out? Explain jury
Right.
nullification to my audience.
So I literally got chills when you say that word because if there's one thing that's beat into us in trial is you cannot even mention those words without contempt of court. It's kind of the unsaid thing that exists in the legal court where basically he did it, but you're going to find him not guilty. And that's really the only way I can explain it. I'm not saying that that's what happened with OJ, but the argument could be made where the jurors were so inflamed by what happened that they decided, no, thank you.
Emmett
We're
Till.
not going to do
There's
this
an
person.
ugly history of jury nullification in the United States,
Right.
where white man kills black man in the Deep South, and all the evidence suggests he did it. The jury just says no, and he
Yeah.
walks. Is that essentially jury nullification? He did it, but we're not going to convict him.
Exactly. And the words cannot even be mentioned in closing argument without the judge literally taking the jury outside the room and putting you in handcuffs. I am not exaggerating. They will hold you in contempt of court for saying jury nullification. So it's something that is kind of this unspoken thing in court cases that can never be muttered, but people understand what it is. Here's the main issue with even if you were going for something like jury nullification. I don't have the court filings, but from what I saw is they hamstrung the defense. They were not going to be able to speak about this child molesting allegation. So the jury, they're gonna sit down this jury, and the jury's going to say, the state attorney, have you ever heard of Cain Velasquez? You raise your hand, yes, you're off the jury. They're gonna cause you right away because they're going to say you're tainted. So now you have a whole bunch of people who aren't fight fans who have no idea who this person is. They see a 6 foot tall person with who's intimidating, and then the evidence is going to show the video of him thinking about threatening somebody, chasing them down, and you have no context of why he did it. The jury's not going to hear that this person was an alleged child molester, all the awful things that make us go, well, it kind of makes sense what he did. So without knowing the circumstances of the case, the jury's just going to look at a tiny piece of this and say, well, it's just some guy who chased these poor people down and shot a father. Of course he's guilty.
Explain to us, because a lot of people will not understand. And when I had once again my former colleague at Bellator, Jen Brown, on my SiriusXM show, one of the things I said is he shot the wrong guy. Can't they
Yeah.
essentially? And please explain how the prosecution could have thrown out the entire. You can't bring up the child molester angle at all because he didn't
Right.
shoot him. He shot the guy next to him. How much was
Right.
that? I made the argument that Cain probably would have been better off if he had killed the right guy rather than shooting the wrong guy. Explain that, please. How they can throw
I
out
totally
that whole
agree.
angle.
There's cases in Texas where somebody literally shot the child molester as he was walking out of his trial, and they didn't file charges against the father. So what I'm saying to you is like there's case law that shows Jimmy, you're right, and the issue is that he shot the wrong. They're all wrong people, right? We have to be very careful with these because nobody deserves to be shot, right? They deserve to be,
His
a trial of
intended
their
target
peers,
was not shot.
right?
Yes.
He apparently what was happening, and again, I'm piecing this together from police reports, is the mother and father of this alleged child molester is being taken to be fitted with his ankle bracelet. So he has a hearing, which Cain is not a part of, which I will say, my position is that is a failure of the justice system right there. So we have a preliminary hearing for the child molester. The judge says, the state attorney says, don't let this guy out on bond. Judge says, I'm going to let him out with an ankle monitor because of these allegations. And from what I've seen, it's only one count of basically molestation. So they let him out and they say, you have to get an ankle monitor. Mom and dad pick him up from court. They're in the front seat. They take this person to get fitted. And that's when Cain is waiting, allegedly, and does what he does.
Once again,
I
real
want
quick, does that speak to premeditation? He didn't run into him on
to,
the highway and saw him and
right.
right. He
It's
had an
almost
appointment
better
that he knew he had to keep, right? Yeah.
it's almost better if he's in the courtroom and he rushes him then, because then it's not premeditated. It's, you're letting this guy out, how dare you, my I don't want to go into details, but you could understand why he'd be inflamed. I will say, in the great state of Florida, we have our flaws also, but we do have this thing called Marsy's law, and a lot of states have adopted this. I'm very surprised that California didn't have something like this, where victims have a right to be heard in court at all hearings. People hire Marcy law attorneys who basically go to the criminal courtroom and say, listen, state attorney, I know you're representing my interests, but I have a right to be heard in this courtroom. And Cain should have been present, should have been able to say, listen, I do not want this person walking the street because of the allegations. The judge should have took that into account. And really, there should have been a victims' rights coordinator that explained to Cain, hey, listen, just because he's out on bond, it doesn't mean the case is over. He's still charged with one of the highest felonies you could possibly be charged with. He's likely going to be convicted. He's likely going to go to prison. Relax, buddy. Like, let the justice system play out. But nobody was able to tell Cain that, and look what happened. And that's terrible. That's sad. And I'm assuming this, maybe the circumstances were different, but that's really a failure of our system, where justice, I do believe, was going to play out the way it should. It just, nobody told Cain, and that's terrible.
So that was leading up to this plea agreement that he has reached. First off, explain the difference between no contest and not guilty. Do we know anything from no contest, or is it all just semantics?
So basically, depending on your jurisdiction, you have three options: plead guilty, plead no contest, or maintain you're not guilty, go to trial and be found guilty or be found not guilty. A no contest plea is basically you saying, you have enough evidence, I'm going to agree to your sentencing, but I'm not saying I did it. From what I've heard, and I don't fully understand this because I don't really do much of that side of the law, it may protect you in a civil case. So they can't use your conviction against you. They can't say, isn't it true you pled guilty to shooting this person? Now we're suing you for civil battery or civil assault. And then you can still have a defense because you didn't technically plead guilty.
Hmm.
And from what I understand, I think Cain is suing civilly the parents for running this daycare, and I'm sure they're going to countersue in a different case for civil battery. So maybe that's why this happened, but I'm not sure.
So you, as a criminal defense attorney, and we've discussed some of the cases you've done some very big cases. This idea that when you plead no contest, when you tell your client the maximum sentence here is life in prison, that is the maximum he can get under California law. How much do you, as a defense attorney, know about the prosecution's sentence before you make this plea? Is it, we're going to go for 5 to 10? Is there a specific year? And please explain, the judge can throw all that out and do whatever he wants. So explain to me
Yes.
the assurances you might get and the pitfalls you might face when your client says no contest in court.
Imagine the conversation you'd have to have with your client when you say, we're going to do an open plea with the court. You can walk out of here a free man, or you can spend the rest of your life behind bars. Imagine that conversation. And, I've had that conversation. I just very briefly, I had a very, it was it was a first time offense, it was a violent felony. The guy got placed on probation, young kid, and he got caught smoking marijuana while on probation. So he's in jail. And as much as we roll our eyes, the state of Florida back
Which I do.
then, this was before legalization medically. This was as if he did methamphetamine on probation or heroin, right? They treated this the end. The state attorney was asking for 7 years, 7 years in a violation of probation, and keep and understand, in a violation of probation, they just have to prove the allegation, right? That's it. So I can't tell you what I told my client, but imagine the conversation of, we have to go to the judge, and that's it. That's our option. Because if we take this to trial, there's this thing, unspoken rule called trial tax, where it shouldn't exist, but sometimes you're punished for using the justice system, right? You're trying to be efficient, so you're trying to get things done the way they need to get done. So luckily, I remember that sentencing to this day because your heart drops because literally life is in your hands, and it's what's going to happen. And I'm thankful that that person was placed back on probation, but he could have gone to prison for a very long time with the state attorney's recommendation. So same thing here. The conversation was had where they said trial is, and a conversation was had with a new attorney. And I just want to touch on that very briefly. I actually think that that was very smart. You have a previous famous defense attorney who's criticizing the judge, criticizing the state attorney, and now we switch attorneys. Judges and state attorneys are supposed to be neutral, but the human element of this guy going on the media criticizing me and now he's begging for my mercy, so I think that it's good that Cain, different attorney, different face. So he does have a new attorney now for the sentencing phase. Um, and anything's on the table. My understanding is life is off the table, but they could still sentence him to 40 years, which is theoretically a life sentence, right?
So you all right. So we all have kind of an understanding of what a kind of a plea bargain is. You don't plead no contest unless the prosecuting attorney says, okay, we're going to ask for 7 years. We're going to ask for 10 years. So
Right.
from what you understand, would you have a plead no contest if the prosecution hasn't said, okay, we're going to look for X number of years? Really?
Right. Sometimes that's the best tactical decision because the evidence is so stacked against you in trial that trial is not a good option. I still feel that there's still something to be said with going to trial, even when it's I'm a former public defender, so a lot of our cases were caught on video, and you still go to trial because you never know what's going to happen, and you never know. Your job is to defend somebody zealously under the Constitution of the United States. They deserve that even if all things point towards them being guilty. And you never know what's going to happen in trial. You never know what a witness is going to say, an officer, and you never know what the appeal process is going to look like. A case that was a guaranteed loser looks all of a sudden, it's tried 3 times, and the state attorney says, "Listen, I don't want to do this anymore. I'll give him 10 years," which would have been a life sentence. So you almost have to roll the dice at a trial. So a conversation must have been had where Cain must and his, I'm sure his attorney did the research, saw what this judge usually sentences first-time offenders to for violent crimes, and talked to the state attorney and said, "Hey, listen, what are you going to ask for?" The state attorney actually gave a statement in this case, and it was not good. They gave a press release, and they basically said, Cain took the law in his own hands, and where he was shooting, there was a preschool, yards away. He could have shot a kid. He shot somebody, and they look like fools now because they cannot let people take justice into their own hands. He makes sure the state attorney mentions we have great police here. He should have let police done their job. So it's too high profile of a case for him the state attorney to just say, "Oh yeah, no problem, probation."
Right. So
So
when all right, so you as an experienced defense attorney in this case, once again, the ceiling is life. You think that's unlikely, but what's good news? What's bad news at this point? If you're sitting there with your client and that judge goes 5 years, that's not bad considering life was on the table, right? 10
absolutely,
years,
absolutely.
15. What are you as an attorney going, okay, that's not a bad outcome. And what are you going, ugh, like, I know life
So
was
I
the
would
ceiling,
say,
but we didn't want 30 years. What's your thought?
right. I would say that if he got life, then we failed, right? He could have got life if he just walked into court himself and pled guilty. So all of this money, all of this time spent, all of this advocacy, and all of a sudden he gets life. It's like, oh boy, this was lost. But you can make the same argument for 40 years. I mean, Cain's 42 years old, right? And so anything over 20 years is theoretically a life sentence, right? He gets out at 70 years old. I mean, he missed his children growing up. So I I mean, what is a win? I don't know. That's a very difficult conversation of, listen, I didn't get you life, but you got 13 years. It's like, great. I mean, I'm sure he'll appreciate it when he gets out in 13 years, but right now he's not going to be happy, right?
Yeah.
Um, this is a tough one. As a fan, as a dad, I want him to get a very minimal sentence. He spent a year in jail, a year on house arrest. That credit will go towards his sentence. So the judge could do something creative here and say, 2 years in prison with credit for time served, right? Get the conviction, show that you're going to be punished, show that you have to do probation now for 20 years or whatever it is. But I do think that the state attorney and the judge, because of the publicity of this case, unfortunately, I think this is going to be a prison sentence. And I hope I'm wrong. I want to be wrong. I hope I'm very wrong. And I do think that's something that it has to be a deterrent, right? Because it has to be, don't take the law into my own hands. Look what happened to Cain. Cain got 17 years when he took the law into his own hands. Yeah, he'll get out and see his kids in college, but he got 17 years. That will make you think twice when you're Googling, going after a alleged child molester. Look what happened to Cain. But it's also not a life sentence. So I hope I'm wrong. I pray that I'm wrong.
Is, that human element of this being a well-known case where, as you said, if this was someone I didn't know, that's not a deterrent, right? Me as a father who's in MMA, I know Cain, I know what happened to him. If this were Joe anybody, is it just more likely they get cupcake time as opposed to Cain? That's going to be bigger. We have to send a message. The size and publicity of this case, has it worked against Cain? It seemed to work for him when it comes to getting bond because all these people showed up, free Cain signs and all that stuff. But when it
Right.
comes to the sentencing, does it work against him?
I have a general rule where there's 200 cases in that state attorney's file. There's no reason for you to be put in a different pile. Let the numbers work in your favor. I think that there's something to be said about going to the media with your issues, but also keep it in house. I'm not criticizing. I don't know the full facts of this case, so I can't judge on what they decided here. But when you criticize a judge about bond and you criticize a state attorney about bond and saying that they should drop the case, all of a sudden now the state attorney's on video talking about, we have to send a message because children were almost shot. I almost never see state attorneys on video ever. That's kind of like, we keep this away from the media. We don't make statements. We do a press release. The fact that I saw this guy on news websites, I'm like, oof, now you're in a different pile. You're no longer a part of the 200 other violent felonies. It's almost better to blend in, negotiate respectfully and figure out what you can do. When you make it a, a celebrity case, it becomes a celebrity case for everybody. And that human element, is the state attorney thinking, wow, I could make a name for myself off of this case? I don't know. I hope not.
This idea that we believe, and this is my last question for you, that we as a community can do something, and we tend to make things public and make things, and with the free Cain signs and everything. Is this a case where that was maybe a bad choice in that it becoming kind of a cause makes the state attorney go, okay, we're going to make an example out of you because we've got to make sure that no one does this again. And this idea that a kind of a civic backlash of, you can get on
Right.
Twitter and say whatever you want. In a court of law, we do things differently. Is there a sense that
Right.
this being big was bad? Is that your thought on it?
Yes, but now's the time where it's going to help. And let me explain
Please.
that. So now we're going to sentencing. And sentencing here in Florida is different from California. I'm not a California attorney, so I don't know exactly how it works. But basically, in Florida, you have a score sheet. They do some math. They add in the aggravating factors. Somebody was shot. Somebody was harmed. Here's your math problem. You now get 100 months in prison, right? And then there's these things called downward departures, right, where you could put on testimony to try to qualify for a subtraction to the math problem to get less time, and that's up to the judge. So now in the sentencing phase, he can pack the courtroom with letters of recommendation, children he helped on the wrestling team, people who he's changed their lives to show, listen, judge, look at this member of the community. Look at these 200 letters of support from everything from a priest to a Dagestani wrestling team to all walks of life, all the people he's helped, all the people he's touched. He should be able to see his children and help them cope with allegedly what happened, so they have their father there. And now is the time where the media will help. All of these things will be taken into account by the judge. There'll be sentencing memorandums, there'll be letters of recommendation, there'll be testimony about his character, and then the judge can take that into account. So it took him a long time to get bond. So it almost felt like a failure at the beginning, but I think now is the time where it's really going to, Cain needs everybody to speak on his behalf, to write letters to the judge, and to help that attorney show that this isn't a heavyweight champion who goes and hurts people. This is somebody who's a family man who helps people on the wrestling team for free, and raises children that aren't even his own, and is a mentor. So I think that's the argument we're going to see at the eventual sentencing with the members of the media and everybody that he touched the lives of.
Pat, really appreciate your time, man. Let everyone know where to find you. You've helped out, by the way, a couple of friends of mine with some legal cases. If anybody gets in trouble, how do they find you, man?
Yeah, absolutely. No comment. So I do criminal defense. I don't kiss and tell. Don't worry. I cannot confirm or deny who has been clients.
Friends
But
of mine.
I do criminal defense, and my wife does personal injury car accident law. We have our own firm. It's called Defender Donahue Law. You can look us up on defenderd.com. So that's Defender D as in Donahue. So thank you so much for having me, Jimmy, and looking forward to seeing you on the mats.
See you on the mat soon, brother. Thanks for your time, man.